family matters encompasses everything from paternity leave to part-time working to flexible working, and if you get it wrong, you can have claims going from unfair dismissal to sex discrimination to breach of contract. So there are quite severe implications. It's a very, very large topic. And so all I'm going to do today is skate through some of the main issues. And I'm going to talk very briefly about what family rights are. And then I'm going to talk about some case law, family law, where it goes wrong, what happens when it gets to court. Caree is going to deal with some case studies on flexible working. And then Caree's also going to deal with some tips for getting it right. At work, what happens when a woman is not only pregnant, but where you have women of childbearing age at work? It's not just pregnant employees, it's women of childbearing age. Firstly, dealing with obviously pregnant employees, all employees have the right to time off for antenatal care, and it is paid. You have to give the employee reasonable time off to attend antenatal appointments, and they get their normal wage for that time off. It may sound a silly question, but what is antenatal care? What does it encompass? Any ideas?
Midwife appointments.
Midwife appointments.
Scans.
Scans. Is a scan antenatal care? That is a question that is asked. I personally think it is, and I think employers would be silly to not to give time off for a scan. But things like relaxation classes. Now, many employers will say, well, that's not really antenatal care. Antenatal care is about care of the baby rather than, but relaxation classes would be classed as antenatal care. Funny enough, there is a query as to whether or not scans are part of antenatal care. In my view, it is, and I think most employers would be on dangerous territory if they tried to say that antenatal care involving scans wasn't permitted. What about fathers-to-be or partners? No time for them. They are not entitled to paid time off to attend an antenatal appointment, even if it's a scan. Obviously, it's quite common now for fathers-to-be to attend scans. No right to pay time off for fathers. That may change. That's one of the kind of paternity provisions which may change. Most employers will allow employees maybe unpaid time off, potentially to take holidays. Some will obviously allow paid time off, but there's no legal right to paid time off with being fathers. Can you refuse time off? Well, potentially yes. I mean, how many appointments are reasonable? How many? What is reasonable antenatal care? The government's figures say that on average, most women will have 10 antenatal appointments during the course of their pregnancy, which is obviously one a month. Often women will have quite a lot more. Some employers will try and put a cap on the limits of antenatal care, saying that it's not reasonable. And the test is that not that all women have to have the time, are entitled to the time off, but it's a fact that they can have reasonable time off, and you can't unreasonably refuse the time off. There's a lot in the notes on this. As I say, we're having to skim over. There's an awful lot of issues in paternity rights. Have a read of the notes, and if you've got any concerns, queries, get in contact with us. Health and safety risk assessment is the second main area covering not just pregnant employees, but if you've got a workplace where you have women of childbearing age and your workplace is one which is potentially risky. If there's hazards includes chemicals, working with chemicals, working with biological agents, but it can also cover, according to the Health and Safety at Work Act guidance, matters such as posture. So if you have people working in cramped conditions, or maybe sitting at a desk all day, potentially is a posture issue. Fatigue is an issue. So, for example, night workers, if you have workers working shift work or working overnight or working late evenings or very early mornings, those are particular issues where, if you have women of childbearing age, these are the kind of issues you should be factoring into a health and safety assessment that you carry out. Movement, if you've got workers doing repetitive jobs on a line, for example, those are areas where, if there is a risk to the pregnant woman or to her child, is an issue which should be factored into any health and safety assessment. So all employers are obviously obliged to carry out health and safety assessments. If you've got women of childbearing age in the workplace, you should be factoring in issues specifically. Even if you haven't got pregnant employees or employees you aren't aware are pregnant, you should be factoring in these kind of issues into health and safety. If there is a risk to the health of a pregnant employee, and that cannot be ameliorated within the job, if you can't remove the risk, women have a right to be offered an alternative role in the workplace. Now, the alternative role should be a reasonable alternative role. It should be, if possible, on the similar terms and conditions, and so it shouldn't be disadvantaging the pregnant woman in any way. If there isn't an alternative role and the risk can't be ameliorated, you have to suspend, and you'll be suspending the employee on full pay. Question as to what full pay is. Full pay is, does it include bonuses? Does it include shift allowances? Does it include productivity bonuses? Does it include performance-related bonuses? There's a case involving cabin crew. In fact, there have been several cases across Europe involving cabin crew where air staff are mandatorily grounded after, I think, 19 weeks of pregnancy. And there's a question there about, well, do they get their shift allowances? Do they get their social working conditions allowances? It's still actually slightly open, which is why I haven't put this case in. But there are certain, and if you're in this situation where you have employees who can't, who have to suspend for these reasons, get in touch with, and there is an issue about bonuses, etc., get in touch. Some antisocial elements of bonuses, for example, you are only getting it because it involves overnight stay, probably they aren't payable. But other bonuses, for example, performance-related, they probably are. What do you need to do if there is well, in some cases you have to perform a specific risk assessment, and in other words, when you have noticed that a woman is pregnant or giving birth or is breastfeeding, you are required in certain circumstances to carry out a specific risk assessment. And that is, if you have written notice of pregnant, birth or breastfeeding, the work must give rise to a risk to the mother or the baby, and the risk must arise from working conditions, for example, working nights, or work processes. That could be the nature of shift work, the way that you undertake the work, or exposure to physical or chemical agents. So in those circumstances, if you work for an employer where there are those kind of processes going on, or people are handling hazardous materials, or working on a line with repetitive processes which could potentially give risk, you must carry out a specific health assessment in relation to that employee. To qualify for maternity leave and maternity pay, the employee should write no later than 15 weeks before the expected week of delivery. The expected week of delivery from the doctor, work back 15 weeks, and then on that, or before that date, that should be no later, not no later, by the way. The employee should be writing to you, telling you the pregnancy, the dates of the expected week of childbirth. That used to be called the expected week of confinement, which is a horrible term. I'm so pleased they changed it. The date she expects her maternity leave to start, and the earliest it can start is from the 11th week before the expected week of confinement. If it's an early birth, the employee has to write and tell you within 28 days of work. Well, of course, many employees may not put it in writing, or may forget, or you just take no work. Obviously, as an employer, when you're paying statutory maternity pay, you can claim back at the majority, I think 93%, if you pay under £45,000 in Class 1 national insurance contributions, and you can claim back 100% plus an extra 3% if your wage bill is under £45,000 in national insurance contributions. If it is not in writing, and the HMRC do an audit, they will not allow you to recover that rebate. You recover the rebate from national insurance, so always get it in writing. Obviously, if they don't, you can pay the SMP, but there's a prospect you won't be able to recover it. when the employee's written to you, you must acknowledge as the employer within 28 days of that notification and notify the employee of the date their maternity leave will end. If there's an early maternity leave, there's an early birth, then you have to write again and notify the revised date. If you don't, and the employee doesn't return at the end of a maternity leave, you have got problems in enforcing taking action against them. There is an argument the employer can just carry on taking maternity leave and you wouldn't be able to take specific action against them. On maternity leave, it's now 52 weeks. It's still split up into the old regime of ordinary maternity leave and additional maternity leave because now there are still very slight differences between the two. In 3 or 4 years ago, there were real complications between the two, and not only that, but the consequences which arose if you did something during maternity leave. For example, on additional maternity leave, if you dismiss somebody, they have far less rights, pregnancy-related rights, than they now do. So it's still split up. As I said earlier, it starts, the earliest it can start, 11th week before the expected week of childbirth. The employee can change that date if they want. They have to write in and give other notice, and they can change. If you return to work, if the employee returns to work at the end of the ordinary maternity leave, there's slightly more beneficial consequences for the employee because during additional maternity leave, pension contributions, pension must not accrue, but everything else does. All contractual rights, apart from obviously wage, because we're getting statutory maternity pay, accruing maternity rights. In other words, if there's a pay rise, it's updated for that employee. And it will, in practice, probably only affect the first 6 weeks and 90% if that's what you pay the statutory maternity leave, but it should be updated to make sure that the employee gets it. Holidays accrued, and obviously, in many cases, employees, if you have a regime where people can't carry over holiday, but they've accrued holiday, obviously in those circumstances, you would be giving a more beneficial right to the returning employee, because you would be allowing that employee, have to allow that employee to carry over their maternity. All employees, mandatory, have had a baby, must take 2 weeks leave. It's a criminal offence on the employer if the employee, and even at director level, I've seen it, people saying, no, I've got to go back, I've got to do my stuff. Senior employees, it's a criminal offence on them. Maternity pay. 39 weeks. To qualify, you've got to have 26 weeks employment by the 15th week before the expected week of childbirth. You'll be still pregnant or have had the baby by the 11th week. If you do, you qualify, and the employer pays. Oh, also, you've got to earn at least the lower earnings limit, in other words, the national insurance level. Up until April this year, this was £104. I think it's gone up to 108. No, don't know. I don't know. And obviously, notify the employer. Payable from day after stop work, or as stated in the notice to the employer, or if an earlier birth, or if absent because of pregnancy, from the 4th week before the expected week of childbirth, SMP gets paid for that date. If the employee leaves her employment after the 15th week before the expected week of childbirth, SMP is paid. Even if you dismiss the employee, it's paid by you, and it's paid for the next day. Rights of employees, rights to return to the same role on the same terms if you come back after ordinary maternity leave, or, and this is additional maternity leave, if it's not reasonably practical, to a no less favourable or a suitable and alternative role. Well, what that means is being subject to lots of litigation. We're going to come to some of those cases. So it's the same job on the same terms, or for AML to a, and if not reasonably practical, to a less favourable or suitable role. Protection from dismissal and discrimination during the protected period. The protected period doesn't start at the 15th week like everything else. It starts from the date the employee becomes pregnant, and it lasts to the end of the maternity leave. Protected period is a concept which is pretty unique in law, because it does allow for positive discrimination during that period. And for example, if an employee is facing redundancy, you've gone through a redundancy selection exercise and the parent woman is selected, that employee is entitled to an offer of alternative work on the same or very similar terms and conditions if made redundant. Again, there's a real issue, and we're going to look at some cases as to what that involves, because there's all sorts of disputes there. Obviously, women who are being made redundant when pregnant are in a very difficult situation. They're not necessarily in touch with their employer. You've got to go the extra mile both to inform and consult. If you don't do so, again, you're in serious trouble. But they have the right to an offer. If there is any job out there which is in any way suitable, that employee should be offered that role, should be going through a competitive exercise as you would do in a normal redundancy situation. That job is that employee's. Employee can return early from OML or AML, got to give 8 weeks notice. Paternity pay. What is paternity pay? Everything's, well, it's the father, isn't it? No. It's anybody in a stable family relationship and who has responsibility for upbringing of that child, the same sex. Paternity leave 1 or 2 weeks. Again, very similar notice requirements, got to be notice 15th week before the expected week requirement, and entitlement is, and to be entitled to paternity leave, you've got to be employed for 26 weeks at the 15th week for the EWC. Statutory paternity pay, taken with paternity leave, it's at the SNP rate. Statutory maternity pay rate, or 90% of the normal wage of that employee's normal wage, whichever is lower. Must take the leave within 56 days of birth, or if the expected week of confinement is later because it's been an early expected week of childbirth is earlier, then within 50. And if the EWC is later, then 56 days of that date. Obviously now we're in a regime where partners can take over the woman's leave, the untaken leave on the untaken maternity pay. And what that is that after 26 weeks, the woman the baby can opt to return to work, and her partner can take that leave in her place. And you get. And what you get there is additional maternity leave and statutory maternity pay. We call something slightly different, but the man has that. They have to give they have to self-certify, and obviously the men or the partner have a right to return to the same role at the end of the maternity leave. Adoption. Adoption. Who's going to take the adoption leave? It is a choice for the adopting couple who takes the main part of the leave and who takes the secondary part of the leave. The primary adopter, in other words, the person who is, and the employer can't do anything about it, even if it looks counterintuitive, even if you're unhappy, even if it's a male employee who is saying, I want to take a year's adoption leave, if they themselves say they're the primary adopter, you have to give them that adoption. Statutory adoption pay, it's not as it is for the normal statutory maternity pay, which is 90% for the first 6 weeks and SNP rates thereafter. It's SNP rates for 39 weeks, unless a very low wage, if the wage is lower, 90% of that wage if it is lower than the SNP rate. They must be earning for the 8 weeks before the date of notification of adoption, which is the equivalent of the 15th week before the EWC, they must be earning over the lower earnings levels. The adoption leave is the 1 year. Paternity leave is it's called paternity leave. Adoption, in fact, it is what it is. It's exactly the same as paternity leave, but it relates to adoption, and it's for 1 or 2 weeks. You either take 1 week or you take 2 weeks together. You can't take 1 week and then one time and then another week another time. It's for that, and that's the same for paternity leave as well. It is for that person to decide whether they're going to take 1 week or 2 weeks together. Again, you've got to give notice 15th week before the adoption match, and you've got to take the leave within 56 days of the placement. Statutory paternity pay, exactly the same as for statutory paternity pay. Adoption, exactly the same as for statutory paternity pay. again, the secondary partner has a right to the untaken additional paternity leave adoption. And so after 26 weeks, the other partner can opt to transfer the leave to themselves, and they get the right to the SNP, or the equivalent of the adoption pay. Again, right to the paternity leave. Parental leave will be employed for 1 year's employment for the days of the leave and have parental responsibility. Employees are entitled to 13 weeks leave for the purpose of care, and it's a maximum of 4 weeks per year per child. And that's up to the, and that's 13 weeks per child up to the 5th birthday, or for the 5th year after the adoption placement. If a child is disabled and is in receipt at the moment of disability living allowance, that's going. We don't know what's replacing it. We don't know what the new criteria are going to be. But if you're aware an employee's got a child who at the moment is in receipt of DLA, then they're actually entitled to 18 weeks up to the 18th birthday of the child. Again, right to return to the same or substantially similar role. Now, you may have your own scheme, but if you don't, then the default scheme is going to apply. And the employee can require evidence of the right to parental leave, and due notice has got to be given by the employee. This is in the notes. I'm not going to go into too much detail. You can postpone as an employee. You've got to follow the process. The process is in the notes. You can postpone by up to a year that employee's parental leave. Right not to be dismissed if you take it or subjected to a detriment. Emergency time off. Reasonable time off for employees to take necessary emergency action. No length of service required, and it's to provide assistance if the dependent is ill or injured, or to make care arrangements. So it's the initial emergency or initial illness, and then consequently time off to take the care arrangements. It applies if the dependent dies, and if there are unexpected disruptions in the care arrangements, or for example to deal with incidents at school. It doesn't cover employees providing ongoing care. It also doesn't cover if, for example, a relative dies. It doesn't cover, for example, the bereavement process. We'll look at a case on that. It is there to deal with arrangements, either to provide assistance to the employee or to provide arrangements. If it goes beyond that and it turns into care, over and above the very short-term assistance, or if it turns into, for example, bereavement reaction, then it's not dependent on emergency time off. It is you can take it maybe onto something else, maybe sick leave, but you can't take it onto this. Therefore, you don't get the protection that you get under these regulations, because again, you can't be subject to the detriment or dismissal for taking this leave. Dependent. What's a dependent? Well, believe it or not, it's not just close relatives, certainly the assistance is for close relatives, but the care arrangements can go beyond that. If, for example, you provide care arrangements to neighbours or to elderly aunts or uncles, that could be arrangement which you're entitled to take. If you can show that, in fact, you do provide care arrangements, or you do make care arrangements on behalf of an elderly neighbour, then, and you want to take time off, as an employer, your document action is going to be covered. So maybe they're entitled, so always inquire further, because again, if you're subject to somebody to detriment because they've asked to take this leave, you could have find yourself in a little bit of difficulty.